I think the Speaker is in a better position to do a comparison. That is, comparing the censure motion and the issues that were determined in court. I have only read the ruling of court. On the face of it, definitely after the court has made a ruling, you would have no reason pushing the motion on matters that have been settled by court. That would be contempt. But I have, like I said, I have not read the censure motion. So the Speaker, who has read both, is in a better position to interpret both the ruling and the motion and draw her own conclusions. If her conclusion is that they are the same issues, they have been handled by court, definitely you cannot have the same discussed in Parliament. It would be contemptuous. If the movers of the motion are not satisfied, there are channels. They can undertake those channels. But I think the bad faith lies in the fact that they were not displaying the motion and the grounds for us to see. So now I don't want to believe them that, this is a different motion, the grounds are different, without reading them. Because up to now, most of the members, and I can tell you 90% of the people who have signed the petition have not read it. So for me, I only declined because I said, without reading this motion, I cannot sign. I can't sign a blank paper.
I don't know why the Speaker wants to act alone. That ruling would have been given in the House. The Speaker is a Speaker while the whole House is in session. That such wonderful rulings would be given when we are seated as a House. So if she sits alone in an office and makes a ruling, even some of us who want to raise issues against us, looks as if we are just attacking and fighting her. I want to appeal to our Speaker to learn to use Parliament in the plenary, to use the plenary. So this motion, first of all, would have been allowed to be introduced in the House, and then thereafter, a procedural matter would have been raised by another member. Because for you, the Speaker, you are the judge, you are just the presiding officer. You don't take decisions alone. So you'll allow the matter to come before the House, before the plenary, as our rules of procedures provide. Then during a debate, a matter of procedure is raised by a member, and then the Speaker takes a ruling. But when the Speaker takes a ruling, when the matter is not before plenary, then you wonder where she derives those powers from. I think the Right Honourable Speaker, with due respect, is overstepping her mandate. She's not allowing the Parliament to work, and that is very unfortunate. For some of us who have been here much longer than some of them, including the speakers themselves, we feel sad that the 11th Parliament shall be judged harshly just because of such, why that insecurity? Allow the matter to come before Parliament, then a member raises this as a procedural matter, and then you as the presiding officer, you make a ruling. It looks more beautiful than sitting in your office alone and authoring a letter to disallow a motion. Because in any case, the Speaker is supposed to facilitate her members to bring business to the House, that these matters go unanswered. If we had discussed this matter as a matter of national importance, the first date was raised, we would be through with it already. But the more we try to disallow, the more we force it out of our way, the more it imposes itself on us. We cannot allow such a thing to be said against Parliament and we don't say anything. It is so sad. Already people are demonstrating against Parliament. We are becoming endangered because of her conduct. So for me, I want to encourage my sister, the Right Honourable Speaker, that she should feel more secure than she's currently doing. Allow business to come to House. She has authority and powers to make these decisions, but in plenary, without us MPs sitting with her, she's not a speaker. She's a speaker because of us. So why do you really want to put parliamentary work? You want parliamentary work to be done in your office as an individual. That is very unfair. Let the matter come to Parliament and let a member, one or two, raise this as a matter of procedure. We get arguments for or and against proceeding with this matter after a court ruling. Then she takes a ruling.
The Speaker has read the motion. I haven't read the censure motion because when they brought it to me for signing, I asked to avail me a copy of the motion itself so that I could read and understand. They did not give it to me. They said they were not giving the motion to people. I was only meant to sign, which I declined. There are various options available to them. One is if you think that the ruling did not bring out what you wanted, you go to court if you are still within time. The second is to reorganize yourself, relook at the motion, remove what was handled by court. In other words, amend it and start the process afresh. But there is also another one, which is the most civilized way. Be civil, be humble. Humility would call upon you to say, in this one, I have failed, I have goofed. Then you go for the next option. I mean, you fight other battles which you are able to fight. You fight other battles to which you address your mind, your full mind and conscience, and say, now I can fight another war. We still have so many wars. I mean, Museveni is up there committing crimes. Why don't we go for him? Will you bring an impeachment against Museveni? If you are you're talking about enforcing the law and the constitution, let's begin with Museveni. We remove Museveni. That is another humongous battle which awaits us. Number two, there are so many other people who are wreaking havoc in government. Number three, there are so many laws to be brought to Parliament and to be discussed. Okay, let's do our work, our core mandate. Let's, for now, give a break to hatred. Let's give a break to opportunism. Let's give a break to, bad faith, and concentrate on our core work. First, their contention was that this service award was illegal. If they contended and still contend that it was illegal, why didn't they, by themselves, go to court? That's number one. I don't know this gentleman called Bwete somebody. I don't know him. So whether he was staged or not is not within my knowledge. If he's a Ugandan who has rights as well to sue when he's complaining, then he has the right to sue. You cannot simply say he was staged up. Why are they saying he was staged up now, after losing in court? If they knew that this gentleman, probably some of them know him, I don't know him, they would have known that he's staged up, then they would have gone to court in their own right. So they could have had the matter determined, on their evidence. I have seen some of them saying, now who gave the evidence? Who did what? How can the matter be concluded in a matter of months? Not 2 days, in a matter of months, because at least I saw it when it was filed. I read in the papers. I even took the trouble to look at the papers. I mean, to look at the court papers. I made copies and said, look, what is this? I mean, judicial review. If I were a judge, it is a matter I could even conclude in 1 day. In 1 day, I could write a ruling. Because we know the principles, it's a matter of reading affidavit, evidences by motion, and affidavits. You do not go into witnesses, cross-examining witnesses, unless somebody requests to cross-examine witnesses. It's just the same way we handled the other Chibalama case. I mean, how long did it take? Well, I think 1 or 2 weeks, it was concluded. That is the nature of this procedure. Because, I'm surprised that some lawyers say, how could it be a matter of weeks? Actually, it took a month or two, I would also have blamed the judge. Why would it take you even a week to make that ruling? There are no novel points. We know the principles for judicial review. You apply the evidence before you, which is in affidavits, and you conclude.